I'm Bryce Auckland. Today we're going to be talking about probate. What is a probate? Well, first of all, a probate is a court-supervised distribution of assets when someone passes away. There's a division in the trial court system between criminal and civil courts, and within the civil court system is a probate court. The probate judge, whose responsibilities are to process probate cases for the purpose of taking assets that someone had at their death and transferring them to the appropriate people. It's a court-supervised process that's a public forum. Why is it necessary? When you die, you may have assets that are titled in your name, like a home or a bank account. In order to get legal ownership transferred to your family or your designated beneficiaries, a court-supervised process is required. The other kind of category of interested parties in a probate proceeding is your creditors. So when you pass away, your creditors, through this public proceeding called a probate, will have the ability to file claims and get paid back potentially from your estate. The other benefit of a probate, from a general view, because it's a public process, this ensures that after someone passes away, that all of their relatives have the opportunity to claim entitlement to the estate, or if the decedent wrote a last will and testament, that last will and testament is put into the court system. One of the basic concepts in a Florida probate is understanding, well, what's in a probate and what's outside of a probate, and what is a probate asset and a non-probate asset. Basically, any item that you own at your death or that somebody owns at their death is potentially a probate asset. This could be a bank account titled in your sole name, a car titled in your sole name, or a property that you might own with only your name on the deed, or if you're on the deed with somebody else without the right of survivorship. These are probate assets, and these are subject to the probate court proceeding to make sure that creditors are paid and, again, that the right assets are distributed to the right folks. If you have gone to the trouble of putting a beneficiary designation on accounts, and we'll talk about this later, and there's more information about this on our website, but if you've made a specific beneficiary designation on an account, for example, if you've made a bank account a payable on death or a transferable on death designation, then that will pass outside of probate. Likewise, if you put somebody on your bank account as a joint account holder, then the ownership of that asset will pass outside of probate. In the context of real property of homes, there's a number of things you can do from a deed standpoint to make a survivorship operation happen automatically at your death without the need for a probate. And those include a life estate deed, joint tenants with the right of survivorship, or a mechanism that's special to husband and wife called a tenancy by the entirety that allows one spouse to pass automatically their interest in a property upon their death. But if you have no sort of survivorship function on an asset, on an account, on a property, then that asset will be subject to this probate proceeding. The other big category of asset that typically has a beneficiary designation, but not always, is a life insurance policy. So things that have a specific beneficiary designation or a mechanism of transfer inherent to them do not come into the probate process. Everything else that did not have a designation is subject to probate. One of the big questions that we get is, should I write a last will and testament, or generally, what is a last will and testament? And a lot of people have the misconception that, hey, if I didn't write a will, then the state of Florida gets my assets. And this is not the case. If you didn't go to the trouble of writing a last will and testament, your assets that we just talked about that are going to be subject to this probate proceeding are subject to what's called the rules of intestate succession. And all that means is that there are default rules in place to transfer somebody's assets if they didn't go to the trouble of writing a will. This leaves assets to a surviving spouse if there's any, and a proportion to children if they're not related to the spouse, or if someone was, if someone's spouse had passed away by the time they died, then to their lineal descendants. And if they don't have any blood lineal descendants, then to their siblings, their parents. And there's a whole hierarchy of family structure or blood heirs that get your assets, and those are called the rules of intestate succession. Conversely, if you write a last will and testament, that allows you to get out of this default structure, and you can assign particular people or charitable organizations, for example, your assets upon your death. That's one of the big advantages of a last will and testament. Florida has some protections for spouses and minor children, so those categories cannot be disinherited. But a last will and testament provides you the benefit of deviating from that structure. And importantly, a last will and testament also has to be admitted to court through this probate process. There are two types of probate proceedings. There's what's called a small estate proceeding or a summary administration, which is available if the deceased has been dead for over 2 years or the total countable assets in the estate is over $75,000. And that's called a summary administration. The other administration is called a formal administration, and that's a typical probate where someone is appointed to become the personal representative, and they work with an attorney in order to do a probate proceeding. Whether or not a small estate proceeding or a formal administration is invoked, the probate will carry generally three main functions. Number one, we're gathering all of the assets of the deceased, and we are going to make sure that those assets are probate versus non-probate. In other words, make a determination of whether or not there's those beneficiary designations that we just talked about. Number two, we're going to make provision for debts of the decedent. And I always like to simplify it and tell folks there's two sorts of debts. Those that you know about, so you might get bills and stuff in the mail, and those that you don't know about. And the ones that you don't know about, you satisfy through a publication in a newspaper of local circulation. So I have gathering the assets, making provision of debt, and then finally, after the debts are paid from the available assets pursuant to some technical rules of probate, we have a distribution of the assets to the appropriate beneficiaries. And that's really the main function of a probate. We dedicate a significant portion of our practice to probate administration and probate litigation. If you have any other questions or if you're looking for more information, visit our website and give us a call for a no obligation free consultation. Thank you.